And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, please hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. And the StreamYard link is down there for anybody that wants to join. We got John with us again tonight. How you doing tonight, John?
Doing good, Keith. Soaking it all in one day at a time.
Absolutely, absolutely.
That's all you can do in this movement, right?
You bet. You bet. You can only do what you can do. It is what it is. And as long as you can just keep making improvements on yourself, that is how we gain knowledge and wisdom. So, we're talking tonight about the maxims of equity and what your obligation is. And as I move forward in my own dealings with the IRS coming up here shortly, that's what we're talking about. Mistake is the door to equity. And all I'm doing is pointing out the mistakes. And one of the major mistakes is the tax classification. So, what I want to look at first is this here is the Florida Tax Review, and it's about equity in Article 1 Court. Is the tax court's exercise of equitable powers constitutional? So, as it poses this question, I'm going to tell you from my knowledge and my research and my interpretation that yes, it is constitutional, particularly if I'm the one in equity, the beneficiary is deemed to be the true owner. And being the true owner, I can appoint somebody to do at my bidding what needs to be done to correct those records. And since it is a tax issue, I should be able to assign that tax auditor as that fiduciary to do the record stuff. And in that, it's just knowledge. Like I said, that graph for the enumeration at birth, the birth certificate, showing how it derives at the local hospital and goes through that system of information, the state's vital statistics jurisdiction. So it's going to include communications with Social Security, Secretary of Treasury, Department of State, Governor, Attorney General, Health and Human Services, DMV if I ever had a driver's license and all that, various different agencies throughout that whole schematic that any of them that have any of those records that need to be corrected. That's all we're doing. And equity avoids a multiplicity of suits. So again, it concurs that in equity, we're going to avoid a multiplicity of suits by using that graph to show them what we're talking about. Let's see here. Get
And the
down into
government already admits that they're trustees at least 4 times, right, Keith? Like the Treasury says they're managing trustee.
Yep, yep. And what we're looking at here, pay attention. It says relieve the judges from the rigor of text law and permit them with Praetorian discretion to wander into its equity, and the whole legal system becomes uncertain. Tax law is not based on equity, and arguments of equity have little force. So, again, if equity imputes an intent to fulfill an obligation, then that is contract. So now we have a tax auditor that can look through all of the contracts for the tax and insurance issues relative to the Social Security that assigned that Social Security insurance number as a taxpayer identification number. And again, that's through the Health and Human Services. It says to most lawyers, the federal courts are the courts created under Article 3 of the United States Constitution. However, The federal courts also include the United States Tax Court, the United States Court of Federal Claims, and the bankruptcy courts and the territorial courts. All legislative courts created by Congress under Article 1 of the Constitution. So again, to avoid a multiplicity of suits, we're going to cover the tax, the federal claim in personam. The federal courts act or operate in personam. The state courts operate in rem, and it's the federal that's in the bankruptcy, and that's what that United States citizen is. It's a bankrupt portion of a business through bifurcation, hypothecation, and all kinds of other things. And the territorial courts, 18 U.S.C. 7, special maritime territorial jurisdiction. That was the enumeration at birth. That was supposedly a communication with Congress. Several of these Article 1 courts have important jurisdiction and large dockets and issue influential opinions with precedential value. 18 U.S.C. 8, obligations and other securities of the United States, includes all bonds and, stamps and other representatives of value. Here we have a presidential value. You have nominal value. You have historical value. You have gold value. You have silver value. You have monetary value. That monetary value is pretty ambiguous one because that involves negotiable instruments, and you can't use dollar for dollar. But what you can do is say a coffee bean equals the same value as your dollar. So I'm going to pay you, since I don't have any of your dollars and I don't have any access to your dollars by law, legally, I have to use coffee beans as a form of exchange or trade. It says, yet scholars typically have not paid much attention to legislative courts other than the bankruptcy courts, which are courts adjunct to Article 3 district courts. Since 1988, when Professor Richard Fallon of Harvard Law School published his important article of legislative courts, administrative agencies, and Article 3, little has been published on the feature and limitation of Article 1 courts. Nobody wants to talk about it. They don't want to admit that they're running Article 1 courts. Perhaps legislative courts are overlooked because they have no clear place in study of constitutional law. It is Article 3 of the Constitution that grants the judicial power of the United States to the United States Supreme Court and inferior courts such as the United States Courts of Appeal and the district courts. Yet Article 1 courts perform the traditional judicial function of resolving controversies by applying the laws to the facts and rendering an opinion. In fact, they resemble Article 3 courts in most respects. You see what they do? They mimic the states, or through the state's blue sky securities laws, they mimic the federal securities laws. Through the states, each one of them has their own uniform commercial codes, which are known as statutes, and they merely mimic each other, which mimic, again, the federal acquisitions regulations. They're all just copycats. It's a matter of the different grammars and the different capacities. Except that their judges lack the salary and tenure protections of Article 3. So they're using their salary and tenure protections of Article 3 courts while conducting their nefarious affairs in the Article 1 courts outside of their tenure protections. That's the importance. What we're talking about, these administrative courts, is Article 1 courts.
Yep. And the two things you got to know when you go into court is there a contract, and what's the language?
Yep. And that's what we're going to get into now, is the language. And I want everybody to pay attention here. Again, that holder in due course doctrine has a default rule. This is from the George Washington Law, George Washington University Law School. This is where most of your high-term politicians go to law school. Your politicians generally go to law school, generally George Washington University Law. A large percentage of them. This is an article by Gregory E. Maggs, George Washington University Law School. You got a place here where you can download it. This is just the abstract. And I'm just going to read the abstract. And it says, the holder in due course doctrine, as implemented by Article 3 of the Uniform Commercial Code, says that a party who acquires a negotiable instrument in good faith for value. Now, the value I acquired it with was printed on a receipt, and I have that receipt, and it was issued by the commanding officer, the general or the governor, who has his signature on there, along with the clerk, the registrar, the state registrar. Got both them signatures on it. Issued to me in good faith, and I did so without a photo ID. No identification, no ID was required. I just gave them identifying data elements over the phone. Okay? And I received that bond, that negotiable instrument, in good faith for value, and it came without notice of certain facts. It came all by itself. Understand that. And without notice of certain facts. And who also meets some additional requirements, takes the instrument free of competing claims of ownership, and who also meets some additional requirements. Those are the data elements. I had to give them some additional requirements, and those requirements were that I had to give them identifying data elements. I had to give them an individual's name and number. And then I took the instrument, and it's free of any competing claims. There's nothing attached to it. There's no claims attached to it. Okay? Remember, when I call up the Treasury Offset Program and ask them if there's any debts, and they tell me no, public or private, and I do a UCC 11 with the state, and they tell me no debts, public or private, guess what? There's no one out there with a notice of claim of anything. So all these kinds of credit collectors and debt collectors and courts posing fines, fees, and penalties that I somehow owe them, there's no actual claim there. The record does not show a claim. And who also meets them, takes the instrument free of competing claims of ownership and most defenses to payment. Pay attention to what it's going to say next, folks. Takes the instrument free of competing claims and of ownership and most defenses to payment. The standard justification for immunizing. Is that immunity? It's an immunizing. Almost sounds like a medical term, doesn't it, guys? See, there's already a standard justification for immunity. A holder in due course from claims and defenses, in that the immunity will encourage beneficial commercial transactions and not a creation of a debt and the deferment of its payment. Does that make sense, John?
Yeah, I mean, it's 2 weeks ago, or is it 3 now? You were talking about the Foreign Sovereign Immunities Act.
Yeah. It's all about those immunities. It's all about the indemnification. It's all about the surety. It's all about the claims that are already there.
You know, in the IRS, the AIR
And
system,
greetings, Hidaka.
AIR. Hey, how are you, hon? The AIR system is actually what controls all the medical claim filings.
Yeah, that's
You know, like there's a FIRE system for the 1099s. Yeah, the AIR system. And it's funny because when you look at, we were talking about last time I spoke to you, we were talking about mentioned the ranking for military. And in the Air Force, there's not a warrant officer.
Yep.
Immunity. Yeah. I'm
Exactly.
curious. You think it's related?
And what's well, and think about this, folks. We live in communities. What's the difference between communities and immunities? So it's just a matter. Absolutely.
Sorry.
So it goes on to say the standard explanation for the various requirements for attaining holder in due course status, good faith, value, lacking notice of certain facts, is that these requirements promote fairness and properly limit the incentives that the doctrine creates. This article questions these conventional policy arguments. It contends that parties can generally recreate the effects of the holder in due course doctrine by using waiver of defense clauses in ordinary contracts. Pursuant to these clauses, parties may specify the precise circumstances under which an assignment of contractual rights takes those rights free from claims and defenses. That's that performance, the specific performance that we're talking about in the indemnifications. As a result, this article argues a justification for holder in due course doctrine must do more than show that stripping claims and defenses encourages beneficial transactions. So in other words, holder in due course doctrine must do more than show that stripping claims and defenses encourages beneficial transactions. It must show some kind of a justification. They're saying that just stripping the claims and defenses by claiming immunity is not a justification. So the justification has to come down to the intent. It must explain why maintaining the doctrine as a matter of law is preferable to leaving the rules regarding the transfer of instruments to private contract. Because, folks, we're talking about equity, and again, equity imputes an intent to fulfill an obligation. If that's so, write down the obligation. It's the settlor, the benefactor, grantor, that actually assigns the trustee as the transfer agent and is allowed to, or is the one that allows the transfer, not the trustee. The trustee makes the transfer upon assignment. This article suggests an alternative economic justification for the doctrine that takes into account the possibility of using waiver of defense clauses as an alternative to making negotiable instruments.
Waiver of defense. I'm sorry, that's just because to me defense means no offense. You have no offense.
Well, yeah,
And waiver of it.
Well, yeah, and that's that equal consideration. I'm going to waive a defense. I'm not going to involve myself in the fight. I see it more as a hors de combat. I'm not in a war. It's a force majeure. There's something greater. There's a greater truth that will resolve it without fighting. That's the true
Exactly. You're not
justification.
having to go, to the match or whatever.
Right.
Yeah.
That's the true justification. And in effect, it's holding down the expenses, the literal administrative costs, as well as negating the debt against the United States. It's qualifying.
Which goes
It's
in the
in,
line. Yeah, it's not
it,
fraud, waste, and abuse, right?
right. It's qualifying the immunity so that they're not suing themselves. United States
Is
citizen
it
means
them
United
suing
States business.
themselves,
United States
or
business
is it
means
us
United.
suing ourselves?
Well, that's what I'm saying. Why would you take it into a court and file a suit if you understand that they granted you a United States citizenship, which is in fact a United States business? Why would you make a claim against them when they're the remedy? They're in bankruptcy. Can anyone make a claim against somebody that's in bankruptcy?
Nope.
Bankruptcy is an estoppel. So why is you making a claim against me? It resolves the issue. There's not supposed to be a claim to begin with. There's supposed to be immunity from claims.
Mm-hmm.
It asserts that
We're
while
suing
parties,
ourselves.
yep, it asserts that while parties could replicate the doctrine through waiver of defense clauses, the holder in due course doctrine spares them the effort. Again, because it's already there. It tells you right here it's immunizing. It's an immunity that's already there. In this way, the doctrine serves as a default rule that may reduce transaction costs and thus may promote efficiency. So here's the 41-page George Washington University Law School Public Law and Legal Theory Working Paper number 386. The holder in due course doctrine as a rule or as a default rule, 1998 George Washington University Law School. And I'm going to show you something here real quick. I want you to look up here in this window. This long ass code thing here. As we go back to the beginning. And we see the HTTP. And then we see this question mark. Okay? And we go all the way to the end. And this is just a link lesson here for you. You can cut all of that out. And still have a copyable link. Okay?
Without the tag on it.
Right. That tag is a tracker. Okay? And it just takes
API
up
key.
room. And it just takes up room and it's part of the AI analytics and this and that. And you'll see a lot of times if you get anything from like Facebook, it'll have the question mark and then FB cloud or clip or something, whatever. Okay. So at the end of this, on this one, we see index equals true. This is telling us this is done by a blockchain on the internet where each keystroke was literally, or this document is literally in there with timestamps that are securitized, naming it that the value, the index, remember we were talking about different kinds of value. The index is the value system, and it's saying it's true. Okay. Just an interesting note there at the end of this one. It's something I've not seen before. But anyway, there's a link to the actual 41-page doctrine on the holder in due course doctrine as default rule. Okay. You guys got anything yet on this before we get into the 20 maxims of equity?
On the coding aspect that you were talking about, people really need to look into XML and how that's set up, and well, most coding to begin with, because it's all predicated for the most part off of a family structure. There's a parent file with a child entity, siblings.
Well, yeah, and parent is a definition
Yeah.
by under the auspices of adoption.
Mm-hmm.
So, and that's what them foundling hospitals are. And that's what those documents are about, is immigrant adoptions. And you are called a parent or a local parentis in legal terms, and you are merely just a custodian. You are not recognized as the actual testator or anything like that, as if they would recognize you as a living being. The only thing they recognize is that record and the documentation. And this is why I keep urging everybody to understand what that ID is. It's not you. It's
important.
It's evidence. It's material fact evidence of the United States business and the trust that operates, that's presuming you as a public servant. So the next one I got is I posted the 20 maxims of equity on my YouTube on El Perro in the community page. So that's where we're at now. Did that today. So just go to the community page on El Perro, and then hit the community page here. First post, and it says equity. Oops. Equity is an ancient judicial system originating in England by which courts apply principles of general fairness in situations where application of the common law would bring about injustice. In other words, there would be no justification. Article 3 of the U.S. Constitution extends the judicial power of courts to both cases in law and in equity. This is the problem. Everybody wants to sit in them courts of law. A court of equity is held in the paperwork. A court of equity is the express trust, proving that the beneficial owner is, or the beneficiary is the true owner. The equity is the knowledge of knowing what that is and how to portray it so that it can't be misinterpreted. So they can't deny the trust. So they can't deny the power that goes through you as the beneficiary. And because you have that knowledge, you can dismiss the trustee. A trust shall not fail for want of trustee. As benefactor, you come forth and you are the one that is allowed to control and settle the matters. While in federal rules of civil procedure combined law and equity into a single type of suit, the civil action in 1938, Federal Rules of Civil Procedure Rule 2, there is one form of action, civil. The distinction between law and equity is still very much alive. Claims in equity afford different remedies, not statutorily defined and limited. Equity actually, when it affords different remedies, it's actually known as creation of remedy, because each and every one of us is very distinct. This is why they do those case laws, because there's something distinctly different. So we got to have a precedent set. There's something different. See, and that's what each and every one of us needs to do, is set forth our own precedent based on our remedies and our knowledge and not some damn opinion. Do not permit a right to trial by jury under the 7th Amendment. Claims in equity afford different remedies. Do not permit a right to trial by jury under the 7th Amendment. Why is that? because that's a court of law. Indeed, equitable claims must be decided by the judge, even if a jury is deciding other claims at law. See, you're actually the attorney in fact. You're the only one that can take that instrument and perfect its title. You're the only one that's in fact entitled. All the others do colorable rights.
That's why they're not allowed in court, because they're real.
Correct. And equitable remedies are generally unavailable when there's an adequate remedy at law. This is why we have to prove the inconsistencies and show the impossibilities. If it's impossible, then there's no remedy at law. The remedy is equal station in life, where you get to perform the same similar functions, but agreed to do so in unison, in commission, and not as a standalone army, a standalone bank, a standalone nothing. 2 or more witnesses come together with the one witness you need on your side. The IRS for its United States issues. The interest on the principal. While they do not constitute binding precedent in U.S. courts, equitable claims and the courts that preside over them are traditionally guided by the 20 maxims of equity, which are certainly persuasive precedent. This is what I'm talking about. When you go forth and do this stuff properly, you should end up with a private relief law, your own private law. It's not a law binding in the U.S. courts because it's outside of the U.S. courts. It's superior to the U.S. courts, in alignment with them, but superior, a profit unto the nations, not some babbling fool citizen resident that doesn't know that he's running a business. And of course, again, not his fault because no one taught him.
Right. But one thing I've noticed in the last couple of years, and I don't know if you have, because they used to have private laws passed all the time. I haven't seen any for probably 3-4 years.
Well, they've had one here recently, but yeah, you're right. 3 or 4 years there was none, and then the year prior to that you saw maybe 3 or 4. The year prior to that was 5, but you go back a number of years and you see there were hundreds.
And it was more prevalent. Yeah, exactly.
Right. Greetings, Imperium Privatus.
Greetings, Keith.
Okay, so I put down in the chat this next part where it says, the 11th Circuit was kind enough to recently gather 13 of these maxims in one place in Slater versus U.S. Steel Corporation, 2016. So I dropped that down in the chat for everybody to copy, paste, and look that up. And it says, but of course, we pride ourselves in creating a more comprehensive list. So the Slater versus U.S. Steel Corp used 13 of them. You don't have to use all of them. Somehow, some way, you can use a limited number of them and still win the balance trial. One who seeks equity must do equity. And if you want equity, then that means if you have to do equity, you must know equity first. I urge everybody to get on board. Like it says, certainly persuasive precedent. This is perhaps one of the most basic maxims of equity. Anstalt versus Ness Energy International, Inc., March 28, 2012. Another case. Simply put, a party petitioning the court for equitable relief must be willing to fulfill all of its own obligations. Study to shew thyself worthy and approved. See, they all go to college and they get these degrees. I don't need a certificate on a wall. I just have to be willing to fulfill my own obligation. And again, that I must know my own obligation.
If you fulfill your responsibilities, you relieve yourself of liabilities, right?
Correct.
And there's a difference between a certificate and a diploma. Certificates are typically earned and cannot be taken away. Diplomas are
Absolutely.
normally purchased like a license and can be, right?
Absolutely. And that's why I did a video on diploma myself. And that's where what we're talking about is a diplomatic post. What do you think they talk about? What do you think diploma means? It means that you're able to go out upon the world and share your knowledge. That's what diplomacy means, sharing knowledge. That's what the diplomatic post is. It's a knowledge. It's a post of knowledge. It's not a post of military communication that might have secrets and codes. It's a post of knowledge. The thing about no tongue shall prosper, knowing that there's many tongues, it's often equates as well as a pass through that knowledge that there are many ways to convey that knowledge, multiple different types of language, all kinds of ways to speak to people and other animals.
Well, that's typically why universities and such get diplomatic or protective status as a needful building, right?
Yep. And that's like a temple or a education system or a hospital or a museum of national arts or something. Those are all needful and protected buildings. And they have a way
Endowments.
of marking them, and yet they don't mark them. I mark mine. I got one of them uh, diagonal black and white signs on my back door and my front door both, and one right up here in my den. This is our temple. It says equity will not suffer a wrong to be without a remedy. And so when it talks about persuasive precedent, it's because there are so many different possibilities of how things can go that we have to be able to create some kind of justification in the remedy side to at least try to make things better and make the parties whole. That's all we can do. It is what it is. In that, we find out more and more so here in these modern times what this credit system is about, and that not only can we, actually bound back from it, a lot of this stuff, and the only ones we wouldn't be able to, of course, would be like the death and illness. But when it comes to, like loss of property or something like that, that's so much more easily reacquired today with these new remedies that we're coming up with. The equitable power of a court is not bound by cast iron rules, but exists to do fairness and is flexible and adaptable to particular exigencies so that relief will be granted when, in view of all the circumstances, to deny it would permit one party to suffer a gross wrong at the hands of the other. Adaptable. So just like I said, you got to learn through the knowledge and be able to fulfill your obligation by studying to shew thyself worthy and approved. And that is by learning to be adept enough to adopt things so you can adapt them, or be adaptable yourself so that you can adopt things with adeptness.
You keep saying shoeing, and I just have to point this out. They're one of the forms in the IRS that they use to um, take away any of our, dividends, interest, anything like that. Also, our rights, lefts, and whatever in the middles. It's it's a divestment and deferment form. Defer.
Yeah.
Yeah. Yep. Chewing,
Confer,
right?
confer, refer,
Yeah.
defer. Yeah. 3.
Yep. It's like a farrier. Sorry.
Equity regards as done, no biggie, what ought to be done. Again, there's that justification part. By reason and logic, objectively, there are certain things like eye for an eye, tooth for a tooth, depends on what you're doing. Each situation has its own precedent. It is a fiction, however, of equity designed to effectuate the obvious intention of the parties and to promote justice. So again, when you come with equity, in order to receive equity, you must come with equity. And when you come with equity, one of the things we're going to read here is coming with clean hands. If you're coming with clean hands, you're coming to promote justice and not to make accusations and take the other party to and file a suit in a court at law. That shows your dual mindedness, and you can't do that. You have to stick with equity. So it comes with a matter of forgiveness and repentance and all that on your own part as part of the mistake, and equal consideration, equal benefit for them to do the same. Equity, and this is why I say, and it agrees, that I don't know that people have any ill intent. I believe most people go forth in life with an obvious intention to promote goodness and wellness in and of and among each other. I don't know that too many people actually make it a concerted effort to go out. And yes, there are some. I'm not dismissing those. But I think for the majority, most people are good, conscious people. They're just blind and deaf. Equity is a sort of equality. And so when you look at the thumbnail for tonight's stream, you see the equity is a sort of equality, and this is a perfect example that when I went down to a local football game when I was younger, I would walk on stilts. Stilts that put me like 4 foot higher than everybody else. And I did so because at the local stadium there was a line of trees I couldn't see over, but if I got on those stilts, I could. And I didn't have to go inside the arena and pay tickets and stuff to watch. I could watch from outside. That's equity. Okay? It's the same
I
thing.
love that.
Look at the thumbnail. It's the same thing, you know? And so again, equity isn't something that you just learn. It's something that you're going to have to understand, that you're going to have to learn how to practice it. As the FMCRA is silent on the question of priority, and as equity is equality, we find that the proper course here is to distribute the limited funds on a ratable basis, such that each claimant receives a share of the fund proportionate to their share of the total judgment figure. This is where, when you get those class action suits and stuff, this is that part where it says, okay, well, anybody that qualified for the suit against the Morris Tobacco Company, they would get a refund or an award settlement, and Morris would send them a check. But because it was such a large class action suit, you might be surprised to get a check for $2.65. Behold, it's quality. That's equity, folks. Sometimes you win, sometimes you lose in that monetary system. But the record will always reflect that, hey, Morris lost, and maybe you shouldn't trust Morris Tobacco Company anymore, right? Whatever. Equity, again, it's the knowledge. So when it comes to equity as a sort of equality, even if you don't win in that situation, it's like my last case 8 years ago. A lot of people think I lost. I won. In my situation, I won because I used it as a principal foundation to educate myself in this stuff, and they'll never be able to pull those shenanigans on me again. Period. Equity aids the vigilant and not those who slumber on their rights. So all these people that want to reach out to people like myself and have me draw up documentation, no, You've got to be the one vigilant. You've got to study to shew thyself worthy and approved. It's not me they're going to take in that back chamber if they want to test you. It's you. They're not going to say, I want to know who wrote these documents so I can test him. They're going to test you. You're the one putting it forward. Why would you put forth secondhand shit?
Plus, they're going to test 1 U.S.C. 1 if you really are in equity or if you're at law.
Anytime, if you know equity enough, they're going to keep wanting to throw contract terms at you. You have to be able to amend those contract terms and remain in equity. What is done is what ought to be done. I already told you, I'm coming with clean hands in equity with an intent to fulfill an obligation. And I've studied to shew myself worthy and approved. And I'm telling you, there's a mistake, and I'm here to bring a remedy so I don't have to suffer any wrongs anymore. You understand that? That's running through these first 6 equities just in one statement, letting them know I know what I'm talking about when it comes to this equity. I'm not going to let you bulldog me anymore. You want to put that down as an obligation? Understand that's a contract. Equity acts in personam. Okay? So equity imputes an intent to fulfill an obligation in that contract. Contracts have equal consideration and equal benefit. If there is detriment, then that shall be suffered equally amongst all parties, as equity is a sort of equality. I will run these people around in circles. They want to play games with me. And that's why it's so important to understand and learn this equity. This is the basis for equitable relief or equitable defense of laches. Equitable defense of laches. That's that immunity. Equity aids the vigilant. I'm not here running around like a babbling chicken with my head cut off, not knowing what I'm doing. I studied to shew myself worthy and approved. I've been very vigilant, and I'm here to aid you just as well as I am aiding myself. I'm here to support your rights as well. It is an education. The knowledge again. Equity imputes an intent to fulfill an obligation. That's again in personam as a contract form. Near performance of a general obligation is sufficient unless the law requires perfect performance. I am not studied in legalese. However, I do comprehend all this stuff running through these courts now is contracts and trust in construction as I speak them into existence. So in my general obligation, I must speak the truth at all times, making sure to coin my words, or I shall invoke the Fifth Amendment and shut my mouth. Equity acts in personam, and again, the state operates in rem, the thing, the documentation, the administration of the estate through that documentation. That is what they operate in. Federal courts act in personam. So it's the federal courts that we go to for equity, like I showed on the form AO430, Administrative Office of the United States Administrative or Supreme Court, United States Courts. What kind of suit? A suit in equity, a bill of relief. Relief, remedy, and cure by reversion and merger of the estate into a new private trust. Equity acts on the duties of people, not objects. Or equity acts in personam, not in rem. So you can't get equity at the state level. You have to go through the federal courts. Equity abhors a forfeiture. largely foreclosed, pun intended, today by statute. The original theory was that if one failed to make a payment for property received on time and had that property seized at law, they could pay the debt late and recover the property in equity. You can still do that today within certain limits. Today, it may be more important to understand the exception to the general rule that equity abhors a forfeiture, which states that forfeiture is favored when, instead of working a loss or injury contrary to equity, it promotes justice and equity and protects the owner against the indifference, laches, and injurious conduct of the lessee. See what happens there? Those laches, it's a lease. There's a contract there already. That's what that identification is all about.
They release you from the hospital. They release you from jail, right? So it's releasing.
Right. You leased your personal services as a latch with indifference, with no notice, and therefore the one that is considered the owner is not actually the true owner because it's in a contract and nobody's recognizing the trust. So when you recognize the trust and you speak that trust law, they can't deny the trust, folks. You catch them denying the trust and know what you're doing, you can have them not only removed from office, but that tenure and pay and all that's all that, and that's no longer protected. Remember? Now you can go after their estate in equity. Equity does not require an idle gesture. If the employee desires reinstatement for strategic purposes, that is a valid basis for denial. In other words, if the employee desires reinstatement into a company that fired him because he wants to learn the business more so he can go out and start his own business of the same line, competing with that employer, nah. That's why they have apprenticeships. Equity does not engage in idle gestures, and the court will not order plaintiff to work as a material handler at Volvo without it being unambiguously clear that she still wants this job. Equity does not engage in idle gestures, and the court will not order plaintiff to work as a material handler at Volvo without it being unambiguously clear that she still wants this job. In other words, she didn't want the job. Therefore, he didn't order it because it was already posed that she didn't want the job. She left rather than get fired, I guess. I guess I used the wrong premise there. And they give you the cases on this, folks. Go ahead and look them up. Read everything you need to until you understand this stuff. He who comes into equity must come with clean hands. In other words, the entrance to equity, like I said earlier, is mistake. So when you find mistakes, you have to come with clean hand and recognize whether they're your mistakes, their mistakes, or everybody's culpable some way, somehow, and be fair and equal about it. You know, if a guy just errantly put down some information that you gave him, then maybe he's not quite so much to err as you are. So fix your own errors first. This is removing the speck from your eye before you go trying to dig one out of your brother's eye. You got to be able to see. He who comes into equity must come with clean hands. The equitable defense of unclean hands requires that he who comes into equity must come with clean hands. And that's right there with the first one. He who seeks equity must do equity. The knowledge and everything that you're researching, you have to be very discerning about it and make sure that you are positive of what you're doing. We have to quit believing. Do not believe me. Do not believe the neighbor. Do not believe the government, for crying out loud. Do not believe your mother. Do your research so you know. Equity delights to do justice and not by halves. This is why I say about full acquittance and discharge, so no person shall be held liable in any court, so that we can do a full settlement and make sure that all creditors are made whole, and that anything that is remainder after clearing all accounts to a zero balance is to be reverted in a merger of the estate with the new trust. That way everybody's made whole. At the remedy stage, a violation having been established, it may be appropriate to resolve marginal doubts against the wrongdoers. The marginal doubt is that I was indoctrinated. I see how easily I was indoctrinated, and therefore I see how easily they too may very well and have likely been indoctrinated themselves. Equity delights to do justice and not by halves. This is the equal consideration of immunity, to resolve marginal doubts against the wrongdoers. Courts should not be grudging in remedy injustice. Equity delights to do justice and not by halves. Equity will take jurisdiction to avoid multiplicity of suits. This is why I'm going to the IRS, because they can work with everybody on the tax issue, including the insurance department, which is Social Security. And those are really the only two real issues that we're talking about. Those encompass all contracts and trusts. Good luck today with this one, it says. While the spirit of this maxim may remain alive, it has largely been subsumed by rules concerning MDL, class actions, collective actions, and case law on the topic. This case does not come within the principle that equity will take jurisdiction to avoid a multiplicity of suits. But that's Ohio Farmers Insurance versus C.O.W.A.R.D.S, 1933. Doesn't say you still can't use it in a case and address an issue such as I'm doing. I mean, the last document I got, and I showed there was zero finances, zero charges, no long title, all this, no bond was found, and yet they seemed to draw up a bond. And then when I showed up in court to have it dismissed, they said they'd withdraw the bond and reissue me a summons. And so I said, okay, but it's got to go to this address. They didn't send it to that address as I expressed. And then when I opened it up, they sent me a summons. I line item vetoed and overrode it and signed as benefactor and all that, and let them know in a further statement attached to it that my intent in filling the document out that way, and the fact that they never sent me a waiver of personal jurisdiction. So again, the court failed to obtain personal jurisdiction in order to proceed in the case. And so then they finally dismissed it. But then when they turned around and sent me a notice, they said costs are taxed to the defendant. So now we have, all kinds of issues, particularly when, what was it, last night I did the video on the employee and juries and surety. And that's what we're talking about, is when they try to bring a jury against me, they can't. When they try to impanel me on a jury as if though I'm applicable to it, they can't.
Well, see, in
So,
here in Colorado, on the appearance bonds, it literally has the sheriff signing as two defendants.
um, imperative, 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 imperative.
Yes.
I don't know what you got going on in the background, but we got to have you mute up.
There we go. Sorry about that.
Thank you. Could you say that again, sister?
And of course, I said here in Colorado on the appearance bonds, they actually have the sheriff or the deputy sign as two defendant.
Interesting.
Uh-huh.
So he's actually signing incapacity of sheriff as we the people for the defendant.
Actually, it's funny because when you look on the tickets that they give out, it actually has the people of the state of versus one that says defendant, another one says state of Colorado, another one says the municipality that's representing the state for the people of, and I mean they have it all kinds of backwards. What I'm finding is when it comes to the employee aspect, because we pay taxes, even if you don't pay income tax, you're still paying sales tax, which that employs or funds all of their income, their compensation. We employ the public. What I'm finding is they're basically nailing us for being bad employers because we're not reprimanding our employees, and we're showing up to be, held liable for them. And they're able to switch that title at the time.
That's why I say study to show yourself worthy and approved, and they can't deny the trust. So when they take people into these courts, it's a big pimping game, like Paul Unslave says. They're pimping you. They're looking at you, and they ought already, by your presence and appearance in those courts, have some kind of psychological drawing board of you in their mind, and they're going to play you. They're going to test you. And that's why I say you can't go into court with me writing documents for you and expect anything to happen worth any good for you, because you didn't study to show yourself worthy and approved. They're going to test you, not the paper. When it comes to the paper, they're going to test you as to what's on that paper. And if you don't know what's on that paper and can't explain it to them, you're screwed.
Keep that question. Go ahead.
Sorry. One thing I found really quick, they're not actually filing those appearance bonds or any bonds into the case, so the case isn't bonded. So what I've done is I made some alterations or edits to make the bond more equitable, and I defined titles because they weren't doing that. And I filed the bonds into the case. I'll let you know what happens. It's gonna be interesting.
Well, but see, what they are doing is when they run somebody through one of those courts, and they tell them, okay, you got to pay so much in fines, fees, penalties, court costs, surcharge, and this and that. So then the sucker goes down there and starts handing them Federal Reserve notes or checks or something. And what they're doing is they're taking those payments and they're putting them in as if though that's like a finance charge for a bond. So as soon as somebody goes in and makes that payment agreement, they can draw up a bond. But the bond is done up in a corporate fashion with a firm name and an obligor number, which are the conversions that I'm talking about. And then they turn around and they pool all those bonds once a week and enter them into the court registry investment system under their name to be traded with for Treasury securities. That's what they're doing. They're mimicking through the state's blue sky securities laws, the SEC securities. So then what they do is they make that exchange for Treasury securities.
But what I'm
Now,
finding is even when they do that and they make the exchange, they do the bid bond, performance bond, payment bond, all the insurance bonds for that too. None of the bonds are actually getting filed on the case or into the case. So the case is looking like, from a paper standpoint or from, record standpoint,
right.
the case is going to look bonded.
Right, because see, if they were entered, and
Yeah.
like I said, if they were entered in my name and it was converted to a firm name so that it could qualify, and that firm name went with an obligor number again, so it could qualify, then why doesn't it show up in their debt system as an obligation? So there's still something there that they're using as an investment, but what it is they don't need the bond. They need you to go in thinking you're the one that owes the money. And so when you make those first payments, they can now draw up their own bonding instrument with your name, the firm name, and the obligor.
Hey, Keith, let me add on to that. You said it's not an obligation. Are they considering that private commercial paper? Because private commercial paper doesn't have to be registered if it's like below 360 days.
It's not it doesn't have a federal government OMB number on it.
And I don't think that would need it if it's below 360 days, according to the Securities Exchange Commission.
That's what I'm saying. It's just like when you go to the bank and you go to closing 30 days later, you don't do things right, and all of a sudden they sell that promissory note because they can. So they're creating instruments and then selling them. But the way they're doing it is they're creating their own internal private bonding system and then trading
through the VCAP program.
The what?
The VCAP program through the IRS and the CAP program. It's a voluntary compliance and assurance program, or voluntary close. Yes, right. That has now been renamed in the post office as the EPS account, right? Yeah, and they actually create bonds from that, the credit, right? We talked about that last time.
Yeah, that works with the what they call the equitable sharing program. Get that, equitable sharing program.
Yes.
For seizure.
In the Justice Department.
for the seizure of property, and it's called an equitable sharing program.
Yep, you can see what the DOJ and the court's viewpoint of equity is just by looking at that.
Yep. So the next one.
Hey, Keith, before you proceed, can I ask a question? You mentioned how the court was charging you costs. So then, is the court presuming you as the buyer or purchaser of the jury summons?
Yeah, absolutely. Even though they dismissed it and said they agreed that there was no personal jurisdiction against the benefactor, they then turned around and again refused to recognize it as benefactor and named it defendant and said that costs are taxed to the defendant. When did you get personal jurisdiction to then tax the defendant? That's the whole issue. So they're creating a tax. They're creating a tax issue. So I'm going to the IRS, and this is just a small $96.06 case, but it's got 93 latches that all show the exact same conversions for the exact same thing.
Did you ever get their definition of the defendant?
Well, defendant is a third-person abstract noun, which in the English parlance is total fiction.
Well, yeah, but I'm saying their definition of the defendant, or did they even define it, is my point.
When you try to define a defendant, you have to define them by name, which is a fictitious name. When they have somebody stand up there on that stand and say, "Can you point out the defendant across the room?" and they point to a man, they just done lied because they didn't know any better. You can't.
Well, that's kind of my point. If you can get them to point out their own, because like I said, on the bonds here, it says that the sheriff or the deputy is the defendant. If you can ask them the question, maybe they can point themselves out for you and save you the trouble.
Absolutely. I see where you're going. Yep. And so the next one says, equity follows the law. As Justice Story explained, and he's a good one, but the courts go by Gibson. Okay? The courts use Gibson equity, where a rule of the statute law is direct and governs the case with all its circumstances or the particular point. A court of equity is as much bound by it as a court of law. And this is where the court of law, in their record, has to uphold to its integrity. And if you find one error, it goes to the integrity. And so if it follows the law, and that record is supposed to be as accurate as possible, and you find inconsistencies that create impossibilities, now you are bound by equity. Again, because you have no remedy by statute. Equity will not assist a volunteer. This is much like the one that slumbers on his rights. An unjust enrichment claim will not lie. However, if the benefit is conferred by a volunteer or intermeddler, this is why I say you got to pay them. And when you were the one that filled out those applications not knowing any better, you were the one that volunteered and intermeddled. Again, you didn't know, but still, you have to admit your mistake. And it's because of your ability to admit your mistake and fulfill an obligation that you intend to help correct those records. Equity follows the law. Equity imputes an intent to fulfill an obligation, and that obligation is compensatory and not a volunteer action. What I did was volunteered false information, not knowing it to be false at the time. After I've studied to shew myself worthy and approved, I find out I am in fact not a resident. I'm in fact not a United States citizen. In fact, a United States citizen means the United States business. Now that I understand that, I understand the tax venues and how this all works in regards to insurance, surety, and indemnifications. Let's get this ball rolling. Equity will not complete an imperfect gift. And like we were talking earlier about receiving something that didn't have complete terms, we're doing the same thing here. Equity will not complete an imperfect gift. The imperfect gift was the entitlement to a United States citizen. And like I've said several times now, nobody else can perfect that title but you. Equity will not make a trust where none has been clearly declared. Public service is a public trust. Public servants are under an oath of the Constitution and are supposed to follow the laws of the United States and moral ethics. Clearly defined as public service is a public trust. A defective or imperfect gift will not be converted into a trust. It doesn't have to be a defective or imperfect gift. See, a lot of people want to say it's illegal to use a legal name. Can't be doing that stuff. No, you don't understand how it's supposed to be used. There are many ways it can be used, and one of those ways is to be a perfection of the immunity in acceptance. And when it comes to those immunities where equities are equal, the law will prevail. This government only gets its powers, just powers, when we're talking about justification and justice and injustice. This government and all other governments get their just powers from the people. In any event, the equity of the taxpayer is no greater than that of the United States. And when equities are equal, the legal title will prevail. Again, you're the only one that can perfect it. Hand it over to the United States for its tax implications. 17. Between equal equities, the first in order of time shall prevail. Who came first, me or the title? The general principle with regard to real property is first in time, first in right. Comparing timing with legal and equitable claims, just like you mentioned earlier, Hadassah. The important issue is timing. Comparing timing with legal and equitable claims. Under the common law, an earlier claim had priority over a later claim if both claims were legal claims. The same was true if both claims were equitable. This is your legacy inheritance, first son, second son. In legal and equitable titles, it's the first son that is given claim to the throne. Funny how it was Jacob, the second son, that somehow got the throne. Just a note, folks. Maybe you got it backwards. Order in time only mattered under the common law.
Really quick on that.
Okay.
What you said was very important. As far as him, the second son, getting the throne, that's because the church requires that the second son be gifted or volunteered for service as a typically that noble family's contribution to the church.
Right, and that was for military purposes. Again, it's a separation of church and state for sure, but it's the church that requires the military. Understand that, okay? It's the church that requires the military, and if the church has a family that has a legacy heir that is supposed to take a family throne, then the second son is gifted to the church for those military purposes. Why would you have a legacy heir sent off for military purposes and take the chance of losing the legacy heir of the seat of the house?
Yeah,
that would right. That would be throwing the things out of order. It would throw legacy out of order.
I agree. I just think it's funny that you mentioned that. Sorry.
Yep. Order in time only mattered under common law where one party had a legal claim and a competing earlier claim to the property was purely equitable. So the legal claim came after the equitable one, and the legal claim claiming that he had priority because he had the first legal claim is only making a legal claim, but he's not superior to the equitable claim. Legal title is only 9/10 of the law. So he has to be able to take that legal claim against the equitable claim holder. He can't just create another legal claim holder and say, okay, well, I have legal title over you. Well, yeah, so of course. But you don't have legal title over equitable title. That can't happen. Equity will not allow a statute to be used as a cloak for fraud. This is why I urge people to look into those definitions and understand what you're reading. Because again, if a statute tells you that you were born in the United States, or that if you agree to that you were born in the United States, then you're a United States citizen, and you don't understand all that, you've been duped into it, you can expose that statute and let them know that now that you've researched it, you've studied to show yourself worthy and approved, and you now understand it's a United States business, and therefore there are tax implications. Therefore, you want to go check that record. You want an investigation on the record, because you're not a tax agent. You're not a businessman. You're not an accountant. You're not a lawyer to determine the legal contracting of it. Nobody ever taught you that. Hell, you didn't even go through civics in school. So you've gone through and discerned for yourself that, gosh, maybe I made some mistakes through there. We better check that out. And particularly if you find out that you made a mistake signing documents in blank and realize that in doing so, it laid a presumption that somebody else got to do everything for you in your name. And that might be part of the problem. You get to close all that down. Mistake is the door to equity. Equity will not allow a statute to be used as a cloak for fraud. So if there's an error, an inconsistency, let alone many that create an impossibility, courts of equity, independently of any statute, will relieve against fraud. You cannot force somebody into an impossible contract. I am not qualified.
There are actually there's a series of forms in the IRS that completely back up what you're saying, and it's for a public employer. I believe there's 7 different ones, even one referring to fringe benefits. And basically, if you have the capacity or the capability to realize, like, who you are and where you are in this, and you can admit that you made mistakes, you can literally say, can you help me with these and help me fix this? And, I need help. I messed up. I've been a bad employer.
Yeah, absolutely.
Yeah. There's one for local government, for federal government. Yeah, it's interesting.
And it goes on to say, if proceedings are seasonably brought after its discovery. Indeed, to use the language of Lord Cottenham, a court of equity will rest property fraudulently acquired, not only from the perpetrator of the fraud, but from his children and his children's children, folks. Okay? Or, as was said in another English case, from any person to whom he may have parceled out the fruits of his fraud. That goes to the conspiracy, the extortion, the RICO. It will, just like making all parties whole, it will not allow these officials to use those statutes as a cloak for fraud. See, those statutes are at-law courts, so they're equitable in certain cases. But those certain cases are where they apply exceptions and have qualifications such as oaths of office and this and that. And you didn't do that with knowing intent and get elected to office or appointed or something, then you're not actually performing the functions of public office. Equity will not allow a trust to fail for want of trustee. Even if a trustee dies before the creation of a testamentary trust, for example, or if the trustee is incompetent at the time she or he accepts the position, these failures would not cause the creation of the trust to fail. This is speaking on like a revocable trust situation where you could assign new trustees. That's all that is. You have the right to control any settlement. That means if a trustee is needed in settlement, you can assign one. Or if you already have a remedy available.
You can replace them in an irrevocable trust too, especially if it's a generation skipping.
Well, yeah, that's what I was talking about. That's what this is pretty much saying.
Yeah, well, I thought you said revocable. I'm sorry, misunderstood.
Well, yeah, a revocable trust is one that you can change the trustees in, and by that revocation, dismiss a trustee that's incompetent and assign a new trustee. Now, once the testator...
Yeah, I'm saying in it irrevocable, there are certain circumstances you can do the same.
Right. Again, but again, an irrevocable trust only happens after the testator passes, and now the will is under execution. Now, if you need to dismiss a trustee, it wouldn't be the executor, it would more or less be the state trustee. There's a distinct difference. See, when it becomes an irrevocable trust, that's when it enters into probate to make sure that the estate property is supposedly going to be executed appropriately. And you're not supposed to be doing that. That's because there's some kind of legal title in there still.
We're going to have
20.
to talk privately about mine because, yeah.
20, the last one we have here. Equity regards the beneficiary as the true owner. There's nothing more foundational than that, folks. Another historical maxim that no longer applies. Bullshit. Common law once provided no action by the beneficiary of a trust against the trustee. It required or provided no action. But today, as we know, equity imputes an intent to fulfill an obligation. If you seek equity, you must come with equity. If you come with equity, you must come with clean hands. That's around the board. So if you recognize yourself as a public servant in public trust, then you are a trustee, and you cannot possibly be the one the trust was formed for. In not recognizing that trust, you are in malfeasance of trust, and that is considered theft. You are withholding property from the beneficiary. In all of your seizures, in all of your courts, in all of the inducement. Says common law once provided no action by the beneficiary of a trust against the trustee, but that has since changed with the common law claim for breach of fiduciary duty. See, like I said, that public service is a public trust, and that they take an oath to a fiduciary duty of that trust. If they are not competent, equity will not allow a trust to fail for want of trustee. You can dismiss them, present the factual evidence that they can't rebut, and assign a new trustee to administrate whatever they need to correct their records. It still has nothing to do with authority over you. Trustee does not have authority over the beneficiary. It just says that it doesn't provide action by the beneficiary. But you can provide it yourself. Does that make sense? Anybody?
Sorry. You can, but you have to know this is where it gets touchy. And especially with dealing with equity in the courts, because equity also implies discretion. And the beneficiary has a right not to know. This is where trust law gets
Right.
dicey, because in just an example that I use to kind of show how quickly this is where when you focus on the titles versus the action, this is where it can go downhill very quickly. Because, for instance, in the Constitution, it says you have the right to life, liberty, and pursuit of happiness, right? Well, in trust law, you can very easily flip that upside down, inside out, and on top of your head by just like this. Life is past tense, therefore you only have the right to the past life. Liberty is actually a military term, therefore you need permission for that. And pursuit of happiness, well, ignorance is bliss. If ignorance is bliss, and the beneficiary has a right not to know.
Yeah, and it's interesting you talk about liberty. That's a military pass.
Mm-hmm.
And that's a military pass to leave a shore.
Mhm.
Admiralty, law of the sea, where you get leave to go at liberty on shore, and obviously not within your naval duties. You still hold a command and respect of moral ethics while you're out partying around, and can get in trouble from the Navy if you don't act accordingly. But you're at
Mhm.
liberty. It's just like at law.
Exactly.
You're still under some kind of regulation. So anyway,
Yep.
that brings us to the end of tonight's stream. You guys got anything to say on the way out? I hope everybody enjoyed the thing on equity. I urge everybody to learn it. It's simple, very short 20 maxims that extend into those cases that it showed. And I suggest people to read them and look into what's going on when it comes to truth and reality of the fact that you've been duped in putting in false data elements, and that's a mistake. That's your door to equity. I'm sorry. I did some research. Come to find out, my dumbass has been saying I've been a resident all my life, and I hope you can forgive me. I repent. I will never do it again. Here's why. That's basically all we're doing is fixing all the data elements, and we are the largest proponent of putting those data elements into the record. And again, not because we did so intentionally, willfully, for any nefarious means, right? But because we were induced through non-education. No one taught us some of the most inherent imperative things we need in order to prove that the United States of America is a good, strong, solid nation. Oops. Looks like we lost Imperium. You got anything on the way out, sister?
I don't think so right now. Thank you.
You
It was a
bet.
pleasure.
Anytime. Well, with that, I want to let everybody know again, I appreciate all your support. Please hit the like, share, and subscribe button down there. And you guys know me. I love you, but I really don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see you next time.